In this video, we'll be taking a look at the influential Scottish case of Bourhill and Young, decided by the House of Lords in 1942. This was a very important decision regarding the concept of proximity within the law of negligence. It is important because it illustrates the notion that there must be a relationship of some kind in time and space between the defendant and the victim in order for a duty of care to arise. The facts are very neatly summed up by Lord Fankerton. The appellant, who is a fishwife, was a passenger on the tramway car which was proceeding in the direction of Colinton along the Colinton Road, which may be taken as a southwesterly direction, and which stopped at a stopping place at a short distance before Colinton Road is joined at right angles by Glenlocket Road from the south-east, that is, on the near side of the tramcar. The appellant alighted and went round the near side and front of the tramcar in order to lift her fish basket from the offside of the driver's platform. Meantime, the cyclist, travelling in the same direction as the tramcar, had come up and, as the appellant was getting her basket, he passed on the near side of the tramcar, and, when mostly across the opening of Glenlocket Road, his cycle collided with a motor car, which had been travelling in the opposite direction, but had turned across the path of the cycle in order to enter Glenlocket Road. Let's go back in time to recreate one of the most influential right turns in legal history. The cyclist would have been coming along Colinton Road as such, and the car would have steered into the path of the cyclist. Mrs. Bourhill at the time would have been some distance away, approximately beyond these traffic lights. The cyclist, who was held by the Lord Ordinary to have been travelling at an excessive speed, was thrown onto the street and sustained injuries from which he died. There is no doubt that the appellant saw and heard nothing of the cyclist until the sound of the noise created by the impact of the two vehicles reached her senses. At that moment, she had her back to the driver's platform, and the driver was assisting to get the basket onto her back and the broad leather strap onto her forehead. It may be taken that the distance between the appellant and the point of impact was between 45 and 50 feet. After the cyclist's body had been removed, the appellant approached and saw the blood left on the roadway. As an immediate result of the violent collision and the extreme shock of the occurrence in the circumstances explained, the pursuer, Mrs. Bourhill, wrenched and injured her back and was thrown into a state of terror and sustained a very severe shock to her nervous system. The pursuer's terror did not involve any element of reasonable fear of immediate bodily injury to herself. The pursuer was about 8 months pregnant at the time and gave birth to a child on the 18th of November 1938, which was stillborn owing to the injuries sustained by the pursuer. At court, Mrs. Bourhill argued that a duty of care had been owed to her by Mr. Young, the now deceased cyclist. The House of Lords had to consider whether or not the damage caused to Mrs. Bourhill could be said to have been reasonably foreseen by Mr. Young in the circumstances that we have discussed. Lord Russell stated, "Can it be said that John Young could reasonably have anticipated that a person, situated as was the appellant, would be affected by his proceeding towards Colinton at the speed at which he was travelling? I think not. His road was clear of pedestrians. The appellant was not within his vision, but was standing behind the solid barrier of the tramcar. His speed in no way endangered her. In these circumstances, I am unable to see how he could reasonably anticipate that, if he came into collision with a vehicle coming across the tramcar into Glenlocket Road, the resultant noise would cause physical injury by shock to a person standing behind the tramcar. In my opinion, he owed no duty to the appellant and was, therefore, not guilty of any negligence in relation to her." This case is influential in respect of the duties owed to bystanders, and continues to resonate even today. Now it's time for Rory Mayo's top tips.
Rory Mayo's top tip. Bourhill v Young was a Scottish case decided by the UK House of Lords as a final court of appeal, and therefore stands as precedent. It is, however, a common mistake to reference foreign cases from countries that have separate legal systems, in particular but not restricted to Scotland, the United States, Canada and Australia. These cases may form a persuasive precedent if the presiding judge feels that the legal principle is valid and applicable, but they do not form binding precedents and therefore should be used with caution. It is important to check where the case was decided. Just because it is written in English, this does not mean that it is an English case. Use Scottish cases responsibly.